help businesses to increase their commercial value, access new markets, engage in different types of business partnerships. They ensure freedom to operate, thus owning or licensing in the key IPR that can reduce the risk of businesses infringing on yours. Ladies and gentlemen, I tried to shorten my presentation, but there's a lot that we could talk about concerning IP. Happy birthday to you all.
Is it your birthday today, Doc?
No, I'll be celebrating my golden jubilee in January next year.
Oh, wonderful. That's good. Thank you so much. Well, we appreciate you. Oh, for them. Oh, happy birthday to all of you. Born on the same day. Entrepreneurs. Thank you so much. Ladies and gentlemen, last but not least, we have Aram Lambo, who is going to talk to us about safeguarding and enforcing your intellectual property rights in ICT innovation proposals. She's going to share with us the secrets to that. So, ma'am, if I can give you the opportunity to share with us your research and the information.
Good afternoon. They always save the best for last, right? Anyway, my name is Rubidzaim Lambo, and I come from Bulawayo. Ngakhulela khona lapha. I grew up at John Smell Children's Home. Who knows that place? Yes, that's my home. And I went to Balm Green Primary School and Founders High School. So from grade 1 up to upper 6, I was there. And then the Hararians took over, and we had to go. So basically, I work as a patent and intellectual property specialist. So what I do is I work with innovators like yourselves. I work with universities, research institutions, NGOs, and anyone else who has innovations that they would like to protect. And I'm specifically focused on the technical aspects of intellectual property. So you'll see that in my presentation, I'm going to talk more about how now we after what Mr. Sabola has said, how do we apply that to ICT-related innovations? And how do we then protect ICT-related innovations? Because I know there's a lot of debate, and like Mr. Alex said earlier in the morning, a lot of innovators do their innovations, especially if it's software, because there's a lot of debate. Okay, you can't protect, software in intellectual property, or you can't protect it in any other way. So basically, I'm just going to quickly go through the options for protection of ICT innovations, and looking at all the aspects that were discussed, but then applying them specifically to ICT innovations. And then I'll look at enforcement, safeguarding, violations, valuation and commercialization, and then I'll also look at cybercrime and IP violations. You'll be surprised to note that a lot of the cybercrime activities that are taking place are actually theft of intellectual property. So people do that intellectual property. So we'll just briefly look at that, so that as you're products for companies or whoever else you're developing for, you have to be aware of how to protect those technologies from theft of intellectual property. So like I said, there's a lot of debate about software patents because they say you cannot protect. One of the conditions of patent protection is that you cannot protect business methods. So if it's a method of doing business, normally you cannot protect that under patents. And there's also the issue of the internet. Once you're on the internet, remember Mr. Sabola talked about territoriality. So where is the territory? Where is the jurisdiction? How do you enforce? When there is on the internet, you kind of like do not have borders. And so when you're in Zimbabwe, someone is infringing, is in Kenya, or is in America or China. How then do you handle this? So how do we protect intellectual property on the internet? And then we're looking also at that enforceability. Can I sue someone in China for infringing my intellectual property rights in Zimbabwe? So those are all the kind of issues that are being debated in terms of your software. And then we come to hardware. Hardware is more straightforward. If it's inventive, it's novel, and it's industrially applicable, you can protect that as a patent. You can also look at utility models. You can also use industrial designs for the aesthetic appeals. And then you can also use the integrated circuits like was mentioned. So in terms of software, there are various options that you can take. So you can use copyright for the source and object code. So remember, copyright is about expressions of idea. So as you write your code, the way you are writing it, and as it is on paper or on the Microsoft Word or whatever other platform you have it on, that's copyright. And then when you look at the trade secrets, you can keep your source code secret. And you can also use data structures. You can also keep them secret instead of disclosing them to third parties. And then patents and utility models will look at the functional aspects of software. So processes, methods, systems, and then the distributable code, and also data structures can be protected as patents. So the key word with software is you do not write a patent or apply for a patent saying, I am protecting software or I am protecting a method of doing business or an accounting system. You are going to say, I am protecting a process for doing A, B, C, D, and how that software now executes. And then we look at the trademarks, like has been mentioned, your brand, your products, your logos, animations, patterns, colors, sounds, emicons. You can actually use trademarks. And then with designs, we look at the graphical user interface. So I'm going to be skipping some of the slides, but basically with software you have to identify the core functions of your software. What are the cores of that software? And then you then determine which strategy you're going to use to protect it. Also looking at how it interacts with the hardware. So usually with a software patent, you have to talk about the hardware. You cannot just talk about a system. It's how the system operates when it's interacting with your computer, when it's interacting with a server, whatever, a router, whatever else. You have to include that in the description for it to be protectable. And then so for example, it could be a software for controlling a machine, regulating the room temperature. It could be monitoring communication network systems or whatever else it's doing, but it has to be linked to the hardware. So here I'm just going to give you a few examples. So like, for example, what the core is, like it could be an apparatus, it could be a system, it could be an algorithm, it could be a method, it could be a network, it could be the process of the processing of data, it could be the software itself. But then if you're able to identify which is your core, then you're able to protect your software. So I don't think I need to spend a lot of time on the software. I'm sure you all know how the name and branding, distinguishes one brand from the other. And usually once you are claiming a name in a trademark, you have to put that sign TM. And TM usually is for those that are not registered, but once you have registered your trademark, you have the ARA sign that you can put on the trademark. So looking at branding, and I'm just giving you an example of Uber and Lyft. So basically with Uber, their branding strategy is about executives. It's about style. It's about the target market that they're looking at. And then when you look at Lyft, Lyft is for the low-end market where it's about sharing your transport costs. So then their branding also reflects on that. So you also need to be aware of what your branding is. And then some registered trademarks in the ICT sector, that Google Drive icon, it's without even the term, it's just registered as it is, that like triangle structure. And then that one is registered as a trademark, but it's a moving icon. So if it moves and it's different, it's unique. Remember, with some of your inventions, you're going to have a platform which has got unique icons for different things. You can also protect that so that somebody else who wants to come up with a similar platform, maybe the platform cannot be patented, but you can prevent people from using your icons on their platforms. So you have to then protect that either as a trademark or as an industrial design. For example, I'll give an example of industrial design. You can have the graphical user interface, the user interface on your laptop, on your phone, that can be protected as an industrial design. And then, like I was saying, the icon itself. This is just the definition that was given. So you can also protect the colors and animations on your platforms or on your apps. And this is, for example, like how Facebook and Snapchat have protected their graphical user interface. The way you are swiping, the direction in which you are swiping it, and the arrangement of all the elements on the interface, those are protectable as industrial designs. And we also have these also registered industrial designs for Apple. That specific design that comes up on your screen on your Apple phone, that is protected. So no other phone can copy that until that design has expired. And also on their smartwatches, that design has also been protected. So basically, in terms of your intellectual property on your software, you can actually have a combination of strategies. You can decide to use your designs, you can decide to use your trademarks, you can decide to use your copyright. But copyright, as you say, it subsists automatically, but you have to remember that there has to be evidence of the date of when you created it. So if you've written a code, you have to be able to store it in such a way that you can prove that I created it on such a date. So some people will say you can email it to yourself and then you don't open that email, it remains like that. Or some say you can print and then send it to yourself, post it, and then you don't open that envelope. So then that will then have a date to say that on this date, I created this software or this code. So different countries have different strategies that they use, but basically you can actually use all three in combination. So copyright. So with software, a lot of people say, copyright is enough, copyright is what I want to use, but is it really suitable for your invention? Is it gonna work for your type of product or invention? So you have to remember that copyright, like I said, it's fixation. It's only you writing it. So it's just protecting the way it's written. So let's say you wrote your code in Java. Somebody uses Python, but it's going to have the same technical output. You see, that person can do that without infringing your copyright because on paper it's different. It's not the same code. It's not the same, syntax or language or whatever it is that's there. It's different. So copyright will not be effective in that way. So if you want to protect the technical output, it has to be more than copyright. So copyright does not protect functionality. Only the way it's written. Exactly. Someone has to copy it exactly word for word for you to say, okay, this person has infringed. So you can see that in terms of enforcement, it can become very difficult to enforce your copyright when it comes to software. And then anything that you write, you can protect. So in Zimbabwe, we also have a deposit system with the Zimbabwe Intellectual Property Office, where you can take your copyrighted material, whether it's a written business plan, whether it's the software, a code itself, or whatever. You can take it to the Zimbabwe Intellectual Property Office. They will stamp it. You go with 3 copies, and then they stamp it, and then they keep 1. You take 2, and then you can also use that as proof of the dates on which you actually have rights to that software. And then, of course, the protection period is longer than patents. And then another aspect of copyright is the open source software. So we all know what open source is, right? Do we use open source in our innovations? How do we use it? Can I just have an example? One example of how you're using open source in your innovation. Yes? Okay, and then after that you then commercialize the product, right? Then you also apply for funding, right? For that product to be commercialized, right? So open source is software that is released under open source licenses. So it's copyright, right? And then there are different types of licenses under which you release this open source. It's very important. It reduces a lot of, the development costs for you. And, you can actually do more quicker and you have less investment. But you have to know what you are doing with open source. So open source is not as open as we think. So it's also important when it comes to ICT innovations, when you're looking for funding or when you're deploying a product in a corporate sector. Because what happens is that we've got 3 types of licenses that govern copyright in this open source. So we've got the permissive licenses. So if you are using an open source license, you have to check what license is it being released under. So for example, the permissive, you'll find your MIT or Apache type of license. So if you see that kind of license, it's very good. You can use that without any fear, but you have to also make sure that as you are releasing that product, you have copies of the original license, right? And you have to attribute everything that you have done, and then you release it and you give it away as you are selling your product. And then we have weak copyleft. So these are a bit permissive, but when you are now building on this open source platform, you have to note all the modifications that you have made, right? You have to make the modified source code available. So if there's anything proprietary or anything that you want to patent on the modifications, unfortunately, you have to also give them away for free, right? And then you also make all the unmodified source code available. So you release all the code for free to everyone, right? So if you see this kind of licenses, you have the common public licenses, you have the Eclipse public license. So when you see these types of licenses on an open source platform, you have to know that this is what you do. So now, I'll give an example that you can use a platform and it has a CPL license. You take that, you build upon it, and then you build this product. You now go and say to a company, you know what, I've got a system for you to do A, B, C, D. And maybe this company is a big company, right? And it's making money. And when people enforce intellectual property, they look at your capability to pay, right? So if now you've deployed it to a corporate company that has got the muscle or the capacity to pay, I will then sue for infringement because I know that the money for paying will come from the big corporate, but not from you. So they'll leave you alone as you are still, you know, if you don't have the capacity to pay. But if you then take that and then that company is using its proprietary stuff on that platform, then there may be some serious consequences on that. And then we then have the viral type of copyright licenses in open source. And these you have to make source code available for all work distributed under this license, including derived work, regardless of modification. So it means even the technical output, everything that you have done, you have to give it out for free. And if you don't do that, they will, you know, you'll have to pay royalties. Like, I mean, they charge you for royalties maybe for the next 70 years. You know how copyright is for 70 or 50 years, depending on the lifetime. So then they'll say, okay, you've infringed on our copyright, and you've done this, and you haven't done this, so you are going to pay us royalties for the next 50 years, because this is the duration of protection of our copyright. So when you're using open source licenses, you really have to be careful. And again, in terms of security, we don't know who has developed that, that platform, so you have to make sure it's a community of developers that is very active, that is funded, that will always be there in the future. And then I'll look at patents. So like Mr. Sabola said, we look at inventive, novelty, and industrial applicability. So those 3 things have to always be at the back of your head as you're developing an innovation. And by the way, intellectual property protection comes before you apply for funding. So when before you even submit your application for any type of funding, you have to have designed your intellectual property strategy. You have to have filed for protection at least, if you know what intellectual property rights are within that product. So it comes before the commercialization. And then you have to know the difference between the invention and the existing state of the art, and this difference should be significant. So in patents, we have what we call patent databases. Who has ever used a patent database or heard about it? Okay, which ones? Which one? Espaceness, okay, from the EU. Yes, another one? The USPTO. Okay, so basically what happens is when you apply for patents, remember Mr. Sabola said you are disclosing to the public so that everybody knows. And then they are put in what we call patent databases. These have millions and millions of documents on all inventions and innovations in the world, right? So you go into that database. If you want to know whether what you are doing has been done before, you go into a patent database, you search in it, and you see. And usually it's also used in terms of evaluation of proposals. If you are in the developed countries, the funders will also then do their due diligence, go onto the patent database, search and see whether it's been done before, whether there's a better method of doing it, or whatever, before they commit their funds to you. So you need to also do your due diligence before you even submit an application. So the most simple database is what is called Google Patents. So when you go on Google and you type Google Patents, you'll find a database that's there, because the advantage of Google Patents is that it's very simple. If you go to Espacenet or the USPTO, you really need to learn how to search on that database, because there's a lot of mathematical formulas that you have to kind of like put in there so that you find the right thing. But Google Patents, you can even type in a whole paragraph and say a method of doing A, B, C, D. It will come up with results, and you can now narrow it down, and then you can see what is available. And also the other advantage of using the patent databases when you're coming up with your innovations is that they also advise you in terms of the trends, right? So if you put Apple in Google Patents, it will show you all the patents that Apple has, or it has also bought, and then you can see what is the trend. So you're able to determine what is next and what will be the next big thing, right? And if you use the WIPO database, it actually then gives you all the statistics in a way that you are just like, yeah, okay, so the trends are going this way. So if I come in, this is what's going on. The citations are going in this way. So people are looking for this, just like what Google does, what people are searching for, what people are looking for. And you're able to position your innovation in a way that is globally relevant. Because I think sometimes we think, oh, I'm doing this, it's going to be new, it's going to be this. And yet, globally, they're already over that kind of technology. They're already over it. They're looking for the next thing, right? And then the information in the patent documents gives you the technical skill. So let's say, for example, the latest iPhone or Samsung. Any patent covering anything in that phone is already there. It's already published in the patent database, because you patent before you commercialize. So right now you go there, if the next iPhone is coming next year, they've already started patenting, right? So those documents are there and available for you. You read through that, you learn, because you disclose how you make it, how you produce it. So all these technical things that you may think are so difficult, or you need a developer in India to do it for you, you can also then play around with those patents, implement what's there, and then you improve upon that and then come up with your own innovation. That will be relevant to global people. So because people globally will be like, okay, so this is the next patent by Apple, but then they're doing it in this way. You look at it and then you're like, oh, okay, but maybe I can do it this way, which is cheaper, which is better. Then you've got something that's valuable, right? That's people globally will be like, oh, okay, we need that. And then this, I think I've already mentioned, that you don't describe your patent or your software in terms of just economic theories or just the simple things. So examples of software patents, business methods, but remember, you don't say business method when you're writing it, right? When you're writing it, we do know it's a business method. It's going to help a business do something, but you don't say that in your patent document. Or in any of your documents. You say it's a process for doing A, B, C, D. And then we'll have data compression, types of patents, whether it's image, video. And then we also have encryption, data encryption. We know that encryption is a very important thing. So if you have technologies that are being used to encrypt or to prevent, access and all that, they are very important with all the cybercrime that is happening. If you have technology that's going to protect and help, people prevent cyber crimes, then you're in the right path, because this is what people are looking at globally. And then we've got gaming systems, image processing, internet tools, search engines, and telecommunications. So these are now the most popular types of patents that are coming up in the ICT industry. So I just have a few patents. I'm not going to go through all of them. So I just looked at the 10 patents that made $1 billion. So you can Google that. It's there on Google if you just say 10 patents that made $1 billion. So the first one is Dropbox, which is a network synchronizing, a network folder synchronization. So this is just a very simple tool, right? We all know Dropbox. So the way it shares files, the way the files are opening and all that, that gave them $1 billion. So at times when we're looking at innovation, we're looking at the most complex things, but yet the simple things can actually make more money because they are relevant to everyone. Everyone wants it, right? The more complex you go, maybe the less, maybe you're targeting just one company, right? But the simpler you are, it's then going to be cross-sectorial. It's going to be a lot of people doing that. And then we also have the firearm, which is, this was the first method of making an antivirus. Very simple. This was developed this patent was for 2004, and this also made $1 billion. Also very simple to say if there is a virus, this is what you do. Simple. But it's ICT, it's technology, and it made $1 billion. And then we also have this game, the Zynga game. So the method described how individual characters and the character teams could challenge others based on characteristics such as abilities, powers, defenses, performance levels, etc. This is a multi-billion-dollar patent. Very simple, and it's not even complex. And this is for swiping. Also very simple, nothing complex. And this is a medical device. This is diagnostics. Very simple. And Facebook, obviously, is there. We have node ranking in a linked database. Apple microcomputer for use with video display. So those are the 10 patents that actually made $1 billion. And then Mr. Sabola talked about trade secrets. And these are protectable. Like I said, Google doesn't release it doesn't protect all its algorithms. There are algorithms that it keeps secret, right? For their search. Some they are patented. You can go on Google Patents and search patents by Google. You'll find out there are lots of patents. But then there are some things that they don't patent, especially some of their algorithms. They keep them secret. But for them to be protectable as trade secrets, you have to have taken steps to try and keep it secret. It must have commercial value, and the secret should not be easily discernible from inspection of commercially distributed products. So I can't just say, okay, you say, my secret is in my keypad, what, but I can see that the keypad is there. So that's not a secret, right? So it shouldn't be obvious. But if somebody reverse engineers your trade secret, unfortunately, there's nothing that you can do. So in terms of maintaining secrecy, you have to limit distribution. You have to mark that it's confidential. So a lot of us work with a lot of people. I think some of you subcontract to third parties to do your development, or you partner, or you do anything. And if in all those partnerships you did not indicate that this is confidential information, and then that party then goes on and implements the same project, you have no recourse at law to say, this person, stole this, because you did not say, or you did not sign to say this is supposed to be kept secret, or it's supposed to be kept confidential. So you have to make sure that, and you have to make sure that you've got some sort of secure facilities and files. For example, you've got password protection, you've got all these little things that are there just to keep this information secret. And you also have to have some policies and contracts with employees and third parties. Anyway, this is for companies. I think it's basically the same. Your encryption, password, firewalls, what, just to make sure that there's evidence to show that this was supposed to be kept secret and this is confidential information. So if anyone that you have interacted with implements this after you've put all this in place, then you can actually then litigate or sue them, or stop them from doing whatever you have to, whatever they're doing to copy your innovation. So also in terms of trying to protect your ICT innovations, you have to be aware of the end goal. What is it that you want to achieve at the end of the day with your innovation? As Mr. Sabola alluded to, intellectual property sometimes can be expensive, so you need to have a strategy. You just can't protect and sit at home and say, that's it. Well, usually what happens is if you do not have resources, you file for your application, right? When you file a patent or other IP, industrial design, utility model, you have like 12 months within which you can designate or then protect in other territories outside your own country, right? So basically what happens is we usually advise for young innovators to file for protection. Usually it's not that expensive. Maybe you need 150, depending on which one. Let's say for a utility model, you file that application, then you start marketing, then you start going to look for funding. Then you even then go and show the investors that, you know what, this is pending, patent registration, and you have your application number. I'm sure you've seen products that are written patent number, AP, what, to show that it's still undergoing the process, but it's already on the market. That means you can go to market, but you've got that, you are going to secure confidence in investors to take over, and then they can go ahead and protect in the world or wherever else you want to protect. So basically, filing is your first step that will actually help you in terms of going forward. So in terms of trade secret protection, you have to use non-disclosure agreement that have been talked about. Then you also have to have non-compete agreements, or within your non-disclosure, you have a non-compete statement. So what a non-compete statement says, it says, okay, I'm disclosing this, or we're working together on this, but you cannot go and do the same thing for the next 2 or 3 years. Usually it's a minimum of 3 years, and it can be up to 5 years. So employees usually have this non-compete, or should have this non-compete statement in their agreements, so that even though they work with you, they know what you have, they cannot go ahead and do the same thing for a specific period of time. And then we also have IP assignment. With intellectual property, remember we're protecting the creations of the mind, remember. So if your employer or developer or subcontractor has developed the system, who owns the IP? Someone says the employer, yes? The company? Really? Based on what? Okay, if you have a contract that specifically speaks to intellectual property. So it cannot be just your general employment contract. Your employment contract should have statements that are specifically assigning the intellectual property from the creator to the company. So if there's no intellectual property clause in your employment contract, then it's up to you to do what you want. So employers have to have this assignment, because the person who creates, at first the law says that is the owner, right? And then you assign. So for example, I don't know if you've ever tried to protect a patent. If you go to ARIPO will not process your application. Let's say if you're at a university and you are an inventor, and this is for your university, they'll say, can you please submit an assignment document, regardless of the fact that there are other employment contracts and other contracts that you have there. They will not process until you submit an assignment document saying that the inventor is assigning to the university. So the university owns. So inventorship and ownership in intellectual property are totally different. I can own something that I didn't create because I've bought it, or by virtue that my employees have to assign it to me, but I cannot be cited as the inventor. So you can, and the employer has to also maintain that right for the inventor to always mention and say that this is the person who invented, even if you own it. So that is a moral right that every inventor has. So you also have to have an employee manual, and then policy and procedures for treating, your confidential information. Okay. So basically, in terms of protecting intellectual property, you have to have a strategy. You have to be able to identify what IP assets are in my innovation, right? Are they trademarks? Are they patents? Then you have to keep a record of them somewhere to say, I've got a patent, I've got a potential patent, I've got a potential utility model, I've got this. And periodically, you have to review and audit to see whether it's still valuable. then you have to protect. Protect wisely. If you don't have the money to protect, then look at trade secret, look at copyright, and how, or at times you can just use a combination of all of them to say, okay, this is secret, maybe this is copyright, this is, so that at least you have a strategy and you know how to enforce. Should someone say they've stolen, should someone steal your invention? By the way, they cannot steal an idea. An idea, if you go and disclose to anyone, you go to a company, you disclose, that's it. You cannot come and go to court and say, they stole my idea. Because we only protect what is, what you have tried to protect. So you should have had made effort to try and protect it before disclosing it, as been said. And you have to also make sure that you know the value. Who knows the value of their inventions right now, if you've got an invention? Do you know the value? How do you value your innovations? Does anyone know? So when you're applying for funding, what is the basis? How do you assign a value to your innovation? Based on? Okay, so the innovation, you're saying the market potential of the innovation. On what basis? What is your baseline? You're saying, for example, let's say you're saying, okay, this is let's say this is an antivirus, right? And you're saying an equivalent antivirus in the market is this amount, right? Is that what you're saying? Or then yours is coming to add value, so it's going to be more expensive? Okay. Okay, so is this on the basis of protected innovation or just any innovation? Okay, so if this any innovation is not protected, then is it of any value then in the market? If you can't assert any sort of ownership to the innovation?
I thought you were asking on the basis of me deciding to protect. So I look at its value on the market and then go ahead and protect before I put it onto the market. Okay.
I was talking about the value in terms of when you're now commercializing or asking for funding to say, I've got this asset, because you need to know the value of that innovation for you to be able to ascertain how much you need to go further with it. But anyway, you are correct. There are 3 methods in terms of evaluating, but let me see. It's right at the end. Okay, so there are 3 methods of valuation, but this is valuation based on the fact that you have protected the intellectual property. So there's what we call a cost method. How much did it cost you to come up with that innovation? So you can, on the basis of cost at the current value, taking into account inflation and every other economic factor, you can come up with a cost method to say, this is the value of my invention. We have the market approach, which is like what he was saying, comparing with other innovations on the market. And then we have the income approach, which will then also look at the income that you would potentially make in a specified, maybe for the duration of that intellectual property. So for example, if it's 20 years, so you come up with a way of calculating how much you would earn should you have commercialized it on your own, or should you want to commercialize it in the future. But they are not going to, it's not just as simple as that, because there are a lot of factors that will come in terms of, if you're comparing yourself with SAP sells their stuff at 1 million, and you've come up with an equivalent. Would you just then value it at 1 million? Just because SAP is charging 1 million for their product? Would you do that? What would you do? Start up with a lower entry. Okay. Why? But did it cost you that much to make it, though? It's not going to, yeah. So you have to also be realistic. Just because SAP has an equal product or equivalent product for 1 million, yours does not necessarily have to range there and say, maybe let me put it at 500,000, you know. You don't just do that. It has to be calculated, and you have to be realistic. Then you can also be competitive, right? So in terms of protection strategy, you register, you document, you have contracts, and your non-compete agreements and your conditions. So this is how you protect. You register it, document, there's evidence, and then this is how you protect your intellectual property. And then you have to have your internal measures, your policies, your strategies, your payments of renewal fees, you're confirming your ownership depending on third parties, subcontractors, everybody who's contributed to that. And also in terms of a funding agency, you also have to, if you're funding an innovation, you also have to make sure that you're funding something that that innovator owns. So if he says he's working with different people, he's doing all these things, then he's coming to you and saying they want funding, and there's no evidence that this person owns everything, then there has to be something suspicious about that, and it will become a risky investment because that person can be sued should the other party have proper systems in place. So with any business, whether you want to do an acquisition, merger, license, joint venture, you want to sell, the valuation is always important. You also have to assess any third-party material. If you're coming in, someone is coming in with open source, you have to evaluate the licenses and how it might affect your product and your clients. You have to identify the IP in their products when they're coming to join you. So if somebody develops your website and they put images there that they did not have permission to use, who is liable? So you subcontract a web developer, they develop your website, they put in images, they put in text, and you take it up, and then somebody says, no, that's my image. This text is mine, it's coming from my website. This person just copied and pasted. Who will be liable in that situation? So you become liable by borrowing on the faults of your subcontractors or third parties. So you have to be careful and make sure that whatever they put there, they own. Or in the contract, you then transfer their liability back to them because you did not approve the use of those images or anything. So in terms of intellectual property and enforcement, when you say someone is stealing my idea, this is what constitutes intellectual property crime. So when somebody copies without your permission and they use this commercially and for non-personal use, when it comes to industrial property, what Mr. Sabola talked about, your trademarks, your patents, usually the type of copying that happens is counterfeiting, which is usually looking at imitation, right? So if somebody's imitating your logos, they're imitating or maybe producing products that are infringing on your copy, on your patents, then it's called counterfeiting. Then we have also copyright-related violations. Somebody steals your copyright. It's usually called piracy. And then, like I was saying, some of these intellectual property violations constitute cybercrime. So like if you look at the types of cybercrime, there's cybercrime, the middle one, the cybercrime against property. So when there are intellectual property crimes like software piracy, copyright infringement, trademark violations, theft of computer source code, it's also constituting cybercrime. And if we look at the statistics of cyber criminal activities, according to this was in 2016. It looked at, it estimated that there was at least about $1.5 trillion worth of the value of cybercrime. And if you look at the breakdown of that, they're saying 860 billion illegal online markets. So when you counterfeit, how many of you are in e-commerce? Anyone who's doing e-commerce, developing e-commerce platforms, selling goods online? So in terms, what kind of goods do you sell?
Well, I'm bound not to say because I'm not sure.
Oh, okay.
I am selling something.
Okay, so in terms of illegal online market, so I'm sure, I don't know whether you've heard that about 70% of drugs circulating in Africa are actually counterfeit. Meaning they look exactly like the original, but they're not. The clothes, the shoes. And so if you have an online platform that is selling counterfeited goods, you are actually committing cybercrime. You have to verify the authenticity of the products and services that you are selling online. And then there is 500 billion being contributed to theft of trade secrets. So a lot of companies keep their information secret. So when you now come up with a technology or method of getting into their system, looking through what's there, and stealing that proprietary information, you're stealing their trade secrets. And a lot of this cyber criminal activity has that goal at the end of the day. Besides stealing money, they come in to steal your private information. So they're valuing that theft to be around 500 billion. And then data trading. So with intellectual property, you develop platforms, you develop tools that have a lot of data and all that. And also the people coming into your company stealing all your information and whatever, also related to intellectual property, and that's around 160 billion. So you can see the impact of intellectual property just on the cyber space, and how the goal of a lot of cyber criminal activities is actually to steal intellectual property. And then I think this will be one of my final slides. So some of the violations that we may not know is that internet service providers have a liability to control intellectual property crime online. They are supposed to help us enforce our intellectual property. So you come up, you've got a website, you've got a domain that's registered also as your trademark, and the other person has also done that. You're supposed to be able to go to your internet service provider and say they need to take down this website, or they need to take down this platform, or they're not supposed to allow it to do whatever. They should have mechanisms in place to say, okay, this is how we do it. So if it's whoever, they should have a system in place so that you can actually get relief for this. So I'm not sure how the internet service providers locally do that, but internationally there's a lot of debate, and in Europe, actually, some of the ISPs, if they do not take action, they become very liable to intellectual property crime. And then we also have domain names. A lot of people say, I need to register this domain so that I can sell them, right? Are there people who do that? So if that domain name constitutes a registered trademark, then you are committing a crime. So if you have a registered trademark, and then you go online, you find that that domain name has been taken by someone who's not even using that domain name, then you are allowed to actually then ask that person to have that domain name taken away from them. So domain name parking is a violation of if it is including a registered trademark. So again, online, if your intellectual property is not protected, it's very difficult to enforce it. So if you say you've got a company that somebody registered, when you didn't even register your trademark, then you can't get relief. So you need to have that registered. If it's registered, there's a process and procedure that you can do that. And then cyber squatting, that person also can be liable if they register, traffics, or sells a domain bearing a name which is identical or confusingly similar to a protected mark. So there is liability for cyber squatting. Then we also have some people use meta tags, keywords, hyperlinks, AdWords to promote the visibility of their platforms. But if you do that using a registered trademark of a third party, so maybe, what example can I use? What kind of meta tags do you use for your platforms? Do you use them? Do we use meta tags to increase the ranking so that when someone types a word, then your website comes first? You use them, right? So if you use a meta tag that's bearing a registered trademark of a third company or third party, then there's possibility that that person may ask your website to be taken down or your platform to be taken down. So you have to make sure that your developers or whoever they are, don't put meta tags that are registered trademarks of other people. And then we also have a lot of licenses that are there if you just click and say, I agree to the terms and conditions without reading the conditions, you will be in trouble. So especially if you're developing ICT innovations, you just don't click and agree, click and agree, click and agree. Know what license it is, know what it requires before you take it up and use whatever it is. And then you also have to commercialize your intellectual property, and that is by licensing, giving people licenses. So anything that you develop, you can give license, you can give non-exclusive, limited exclusive, you can give royalty-free licenses, or you can get equity. Then you can sell, outright sell, and say, you know what, I've done what I've done, I can do something else in the next few months, sell it, get money, or that will you will use as capital to start on another new project. And then you can do your spin-off and start up companies, or you can do core development with third parties as you mix. So thank you, everyone.
Yeah. I don't know if I should say amazing, or should I say impressive, or should I say, I don't know, we want more, you know? So thank you so much, Ms. Mlambo, for opening our eyes. Some of the things that she was talking about, I was saying to myself, oh my God, I think most of us here are doing that. You know, who got the shivers from that? Who's guilty like me? Yeah, I think there's a lot of us. And I think the safe thing is, although they say lack of knowledge is not really like you are innocent, that's what the lawyers would say. But I think we learned, personally I learned a lot from the presentations for this afternoon. Any questions, remarks, comments, value additions, corrections? Did that not affect Matinye Pera? Or, yeah, pick up right there, tell one, and then Madam and Sir for now, and then we'll go to the next. Okay, I can see you.
Actually, I just want to comment on the issue of internet service providers.
Mm-hmm.
I'm not sure what she said is done by the internet service providers, because I've seen a lot of intruders into the system.
Mm-hmm.
And users, they come back to the service providers and they say, I've seen a lot of intruders, my data is just gone. But she said the internet service providers, they need to secure the system.
Mm-hmm. So you want clarity on that?
Yeah,
how?
I just
on
want
the
clarity,
how.
yes. Because
okay, maybe just not that, ma'am. Then you can respond.
I've heard a lot of youngsters say they can download or create some apps which can enable them to intrude into the system. So I thought this platform, as the presenter, she can help us as the service providers to say how best can we curb some of these issues.
Okay, thank you. Next person here. Where's the other one? Oh, ma'am, there's ma'am there.
My question is, what are the application fees for filing a patent with
What are the
ARIPO?
application fees?
ARIPO.
ARIPO.
And how much time does the application process take?
How much time does the
yeah.
application take?
Yeah, the reply.
Okay, next. Jataurwa. Okay. I think there's a gentleman here. Okay.
Afternoon, everyone.
Afternoon.
Yeah, mine is not a question, but it's a comment.
Okay.
I would like to comment on the workshop that it was really a powerful workshop.
Thank you.
I learned a lot in this workshop.
Mm-hmm.
And I further request that the presenters may send their presentations through our email addresses so that we can keep on going on and on to revise them.
Yes.
Thank you so much.
Okay, thank you so much. Gentleman there.
Thank you. One of my question, I think there's someone asked the question, but I just want also to find out if there is no response to the application for a patent. What are the procedures that one can take?
If there is no response.
Yes.
Response from ARIPO when you apply. What exactly?
Yeah, exactly.
From you've sent your requests, and then it's not responded to.
Yes.
Okay, thank you. ARIPO and Ms. Mlambo, if you can respond to those issues.
Okay, all right, thank you. So in terms of internet service providers, basically when it comes to liability of infringers, so the first level you are talking about is you need to have a mechanism, a legal mechanism in place, or it's a policy or guideline that in terms of actions, when somebody says, okay, you know, you're hosting or you're allowing for someone who's infringing on my intellectual property to be using your system and your network, you need to have a policy and procedure for that to say, okay, how do you verify that this really is the owner of the intellectual property, and if this person is infringing and all that. So there are guidelines. I think online, if you Google, there are lots of guidelines, or you can seek a legal, your lawyer can actually help you come up with that, so that there's a takedown mechanism that is there. And then now in terms of children who are coming in and then developing apps to actually then you know, circumvent your protection measures, is that this is where the ICT innovators come in. You have to keep ahead of what's going on. You need to make sure that you have technology or security measures in place that prevents such from happening. So you need to be investing or looking around even on patent databases to see what are the latest technologies that can prevent your network from being, you know, from being hacked into or all that. So it's about investment and knowing what is the best quality technology protection measure that you can put in place that can you know, prevent. And then you always have to review these things maybe every second year to see whether that protection globally, what's happening, has it been hacked by somebody else, and if it has, you know, some of these companies that provide these security measures, they actually update maybe every year or every 2 years. So you also make sure you have all the updates in place so that you prevent. And then with these hackers, if you know them, I think what I've seen the trend in the US, I think there's some kid who hacked into Facebook and all that. They take them, they employ them, and then they actually use those brains to try and develop better mechanisms. So it's a strategy that some companies are using to say, okay, these kids are very brilliant. Yes, they're using their brilliance for the wrong thing, but how can I then say, okay, can you create something that will prevent this from happening, right? Yeah, and then in terms of how much, I think Mr. Sabola will do that. And then in terms of length of time, it really depends. When you are submitting a patent application, and also it actually depends on what you are looking for in terms of how much. There's industrial design, there's patent, there's utility model. All of them have a different cost, a fee structure. And then there is, in terms of length of time, it depends on whether you fulfill all the requirements. So when you're submitting an application for a patent, for example, you need to have a specification which has a description, which has claims, which has drawings, and all these other things. So if by the time you submit you do not have all these documents, your application will not proceed. And then if any response comes from the office to say, please submit this, for example, the assignment is very important. If it's a company applying and the inventor is different from the company or whatever, you always need an assignment document, and this is where a lot of people delay their applications if you don't have that sorted. And if you don't get a response, you call. both Zippo, we as lawyers always do that. We also come across that. We call them, we actually go there and follow up on our applications. You have to know the timelines. For example, the first response should come within 1 week, which is like your Form 12. If that doesn't come, you call and say, I did not receive acknowledgement of receipt of my application. And the next stage, they will actually tell you, okay, in the next week, you're supposed to get this. If you don't get it, you call and you follow up with them. Sometimes it's their postal system, and sometimes it's probably their network system that hasn't, processed all that.